Hey everyone, this video is part of a series I'm developing on the topic of shunning among Jehovah's Witnesses. Per the thumbnail and title of this video, you'll infer that I'm addressing why secular authorities here in the West, excluding in specific circumstances, are uniformly indifferent toward these immensely harmful policies. This raises an important question for those who've survived such inhuman and cruel punishment. Why is nobody doing anything about this? Are authorities unaware of the full scope of such injustices? That's what we'll be looking at in this video. If you are searching for a discussion on why the Jehovah's Witness disfellowing policies are objectively immoral, I released an exhaustive analysis of the subject in a work entitled Jehovah's Witnesses and Shunning. It'll be linked below in the description and in the end screen. I detailed why it's not just some protective or loving spiritual provision, as they would have it, but in fact an act of aggression. I showed what the psychological science has revealed on social exclusion and how enormous the trickle-down consequences are on marriages, families, and the broader community. For those of you Bible believers out there, I even demonstrated how it's wholly foreign to scriptural teaching. But if it is such a diabolical and destructive act of belligerency, why are the secular authorities apparently so aloof to it? Stick around and you'll see why. Hey good people, thanks as always for stopping by. So just to start off, there are situations where Western democratic courts are intensely concerned with excommunication policies among various religious denominations. Ever since mass media expose of the Catholic Church in 2002 regarding the systemic cover-up of sexual abuse claims, the authorities have globally taken a dramatically different posture toward clerical privilege and internal procedural policy. It's important to note that this is the broader context in which religious membership decisions, shunning essentially, is being had. And you'll see why that is shortly. Sexual abuse is not a Catholic problem by any means, and it's not even exclusively a religious problem. As the light continues to expose how a separation of powers between institutions create blind spots where the very worst of human evil can flourish, this is becoming more and more of a priority in progressive societies and judiciaries. Many mainstream religions have become famed for this sort of thing. Unfortunately, due to the prevalence of this problem and the size of some of these churches, Catholic priests and other high-ranking clerics have almost become synonymous in our culture with the term child abuser. It's a huge systemic issue. But sex abuse cover-ups have been exposed in the public school system, senior care facilities, especially Hollywood lately, and even my native Royal Canadian Mounted Police establishment. It's a global systemic issue that results from, among many things, an autonomic separation of powers. As we've learned through inquiries like several conducted recently by the Australian Royal Commission, the threat of expulsion from a church, and thereby often one's entire community, can be tremendously instrumental in hiding such serious crimes. And the witnesses are an example of that. So you'll see this is going to become a recurrent theme in the media probably for decades to come. Western judiciaries are not oblivious toward the practice of excommunication, especially when it concerns sexual abuse or other crimes. I'm noticing this concern in countries particularly fashioned on the British paradigm, such as in Canada, Australia, New Zealand, and Norway. But still, why isn't disfellowing simply outlawed altogether? Well, this is why that recent Supreme Court case in Canada between the Highway Congregation of Jehovah's Witnesses versus Randy Wall was so significant. Of course, I'm not able to comment on every case that has indicted this practice, because not only are there distinctions between various forms of religious excommunication, but the judicial format is also incredibly unique in every country. But this trial was particularly interesting because it clearly demonstrated the posture of most democratic judiciaries toward this practice. I want to stress that what happened in this case exemplifies the attitude of most progressive courts, and that's why it's of interest to me. You see, what was so perfect about Randy Wall's situation, that if anyone would have had a chance to take down the watchtower, it really should have been him, are a couple of things. One, Wall had sustained measurable financial damage to his business due to being disfellowed by the witnesses. Two, Wall was not even directly asking to be made whole on these losses. He was merely asking for a procedural review of the Highwood congregation's handling of the matter. If anyone could have gotten the ball rolling and established a precedent where the courts may involve themselves in religious proceedings, it would have been him. And not even he could do it. Believe me, the courts are not oblivious to the very destructive forms excommunication takes, and that'll become evident as I go on. Now sadly, when that trial took place, this was the extent of many people's research into what actually happened. Watch this.
And the congregation elders took the decision to disfellowship him. That word is used by Jehovah's Witnesses. Jehovah's Witnesses don't use the word shun or shunning. They refer to it as disfellowship, disfellowshipping, disfellowshipped, because that really gives the sense of what's taking place within this particular religious community. Disfellowship literally means no further spiritual fellowship with the individual. And as I point out, sorry, Chief Justice. As I point out at paragraph 22 of my factum, the nature of the relationship then of a disfellowship person is not completely shunned. The disfellowship person is able to come into the congregation, to the congregation meetings. They're able to attend in the Kingdom Hall of Jehovah's Witnesses. They're able to sit wherever they like. They can sing the spiritual songs with the congregation. As far as their family members are concerned, normal family relations continue with the exception of spiritual fellowship. And the door is not closed to Mr. Wall either. The person who is disfellowshipped can, after a period of time, ask to be reinstated in the congregation, because that's the purpose of the discipline.
Whether or not you believe that lawyer for the Jehovah's Witnesses, David Nam, was lying, which is what countless online activists claim, many don't realize how trivial this detail was to the question before the court. They don't realize that the ruling would have been identical either way. The issue at hand was not how harmful excommunication is, or even to what degree of censure survivors endure. It had nothing to do with that. The question before the court was this: what are the limits of judicial review? More specifically, when does a religious membership decision become the business of our justice system? This is what defines a case as being justiciable. Justiciability was one of the central questions in this trial, and the answer that was handed down from Canada's highest bench, unanimously I might add, was that the court has no business in membership decisions among the Jehovah's Witnesses, just as they have no authority weighing into situations where you're kicked out of your weekly poker tournament or excluded from attending your brother's wedding. Period. Now I'm going to spend a little time on some interesting questions which came up in this trial, and then I'll conclude by answering whether the situation is truly hopeless, whether reform to the disfellowing policy is really impossible. But let's get back to what was decided in that trial. I've established that it wasn't about how harmful these policies are or to what extent people lose their community when they are disfellowed. The question was whether the state has any business in religious membership decisions. Early in the case, an important distinction was made. That distinction was whether the Jehovah's Witnesses, otherwise referred to as the decision maker, qualify as a private voluntary association or a public decision maker. It's important to understand that these are legal terms. They're considered a private voluntary association for specific reasons, not least the fact that they're unpaid. It's not a labor relationship. There are no property or contractual obligations, and are therefore exempt from any kind of judicial or even procedural review. For example, I was born into a family of Jehovah's Witnesses, and so I would say my act of joining this group through baptism was not exactly voluntary. I was 13 years old. But that's not what they're talking about here. I was a voluntary member in the sense that they did not hire me at my baptism as a paid employee, cleric, or staffer. If Randy Wall was terminated as a paid member of a political party or even worked for a not-for-profit organization, then this would be a completely different story. The lower court's decision to subject the Highwood congregation to some kind of judicial review might have been upheld in this appeal, being within the purview of the courts, but the witnesses don't qualify as such. Interestingly, it was revealed that Wall might have gotten closer to involving the courts had he asked for a different provision which in certain limited cases do allow for a kind of private remedy of procedural review within religious contexts. But David Nam showed how even that provision did not qualify, given how the religious membership of Hutterites, in that particular precedent cited, entailed certain property rights within the colony. As I said, there are situations where the law is concerned with religious membership decisions, but they're very limited in scope because even practices like shunning qualify as ritualistic or ceremonious in nature. There was kind of an amusing point where Nam said that from the ground up, disfellowing is a religious discipline. It begins and ends with prayer. The documents are full of scriptural quotations mentioning Jehovah and Jesus. And he quipped, "Should we subpoena Jehovah and Jesus in this trial?" Admittedly, it's tragic when people's social community gets weaponized against them like this. But there is simply no provision within the law that mandates anyone to commune with ones they want no contact. It can interfere where individuals have lost property or been discriminated against in civil rights scenarios, but the law must remain consistent with itself, and you can be thankful that it's like that. Otherwise, life would be completely arbitrary. So I'd like to repeat, I know this is one case in one small country, but why it's significant and not worth getting your hopes up that the law will crush this policy is because Canada is one of the most progressive countries in this regard, and even they see why the law has to stay out of it. Does this mean, however, that there is no hope for change to this destructive policy? Well, not exactly. As I've shown, the law does involve itself in extreme situations. Mr. Nam even confirmed that the Jehovah's Witnesses do not shirk their liability in cases of defamation, for instance. But I don't think this fight should be done in a courtroom. I really believe that these policies are bound to relax with the growing activism online against the witnesses. It is getting increasingly difficult for members to avoid the constant inundation of press and negativity surrounding the society. There's also a growing fifth column within the faith itself that is exerting a lot of pressure to reform. The situation is hardly static. Remember, this organization operates like a business in many fashions. When it begins to affect their bottom line in the form of stagnation, loss of members, and credibility, they'll have to get in line. It's happened to the Catholics. Why wouldn't it happen to the witnesses? But in future videos, I'm going to show how you can use their policies to avoid being disfellowed. And if you are presently disfellowed, I'll also show how you can either get back, if that's what you want, or else make the most of it should you wish to stay out. There are ways that you can retain your family and extended community to some extent if you've been expelled, but it takes a lot of finesse. So this is where we are. Disfellowing is immoral for numerous reasons, especially psychologically and existentially. Having said that, secular law is likely not going to bring about reformation to such policies. That'll be at the behest of cooperative internal and external activist work. And I would sincerely be shocked to see disfellowing continue beyond an extended decline of membership in the faith. Tell me what you think of all that below in the comments. Honestly, guys, I gotta say, even though I'm not able to chat with everyone, your constant engagement really does make my day. Y'all have such fascinating perspectives that interest me as I'm carrying on about other things. We may not agree on everything, but we can never dismiss each other's sincerity. Thanks for stopping by and stay tuned. Take care. Hey guys, did you like this video? You know what to do. And if something I mentioned today resonated with you, click one of them cards on this screen. I have lots of related content sure to interest you. Thanks as always for your views, and we'll see you next time.